Welcome once again to Lehto's Law. Here's Steve Lehto.
Caleb sent me a note from Forbes as a story that he said I should look at, and I agree. And, Uber is in the news quite a bit the last few years. Uber's a big deal. And Uber's now been ordered to pay $1.1 million after a blind woman says she was refused service. And this is one of those stories where at first you go, wow, that's an amazing story. And then you realize this was done after she went to arbitration. This was not a court that did this. And so a lot of these different services, shall we say, have in them a clause that says if you use our service, you agree to not sue us. And if you have a problem, you've got to use arbitration. And the arbitration is a forum that we will choose and we'll set it up. And the thinking generally is that when someone else gets to pick the rules in the game you're going to play, it gives them an advantage. So the fact that she won $1.1 million after going through their arbitration lends a little more credence, I believe, to her story. So Rachel Sandler wrote the story for Forbes. A San Francisco woman was awarded over $1 million by an arbitrator this week after she claimed Uber drivers repeatedly denied her rides because she's blind and has a guide dog. That's the latest case where the ride-hailing giant's drivers' status as independent contractors has been called into question. And that's another part of the story is that Uber says, look, we're an app. We're a company that makes an app. And the app hooks up drivers with people who need rides. Okay, you need a ride? You want to give someone a ride? We'll just put you two folks together and you do your thing. And they've been arguing that the drivers are not their employees. The drivers are simply people using the app, just like the riders are. Well, the arbitration case was filed by a San Francisco resident in 2018 and accused Uber of violating the ADA, American Disabilities Act, after she was harassed or denied rides on 14 occasions in a 2-year period, and that caused her to be late for work and also eventually to lose her job. The central legal question involved whether Uber is subject to the ADA and therefore responsible for discriminatory behavior of its drivers, who they say are independent contractors and not employees. And so this is an issue they've been squabbling about for a while now, not just in the U.S., but in other countries. The question is, are these drivers independent contractors or are they employees? And the reason that matters is Uber responsible for the actions of its drivers? The arbitrator found that Uber is subject to the ADA, regardless of whether its drivers are independent contractors, because it still has a contractual relationship with drivers and failed to, and this is a quote, prevent discrimination by properly training its workers. Of all Americans who should be liberated by the rideshare revolution, the blind and visually impaired are among those who stand to benefit the most. However, the track record of major rideshare services has been spotty at best and openly discriminatory at worst. That's a lawyer who's represented the claimants in this case, speaking in a statement. Now, the obligations owed by ride-sharing companies under the ADA is a question being debated in the courts. Uber's facing a lawsuit claiming it violated the ADA by failing to provide its accessible ride service, Uber Wave, to wheelchair users in New Orleans, though it is available in other cities. Uber and Lyft reached a landmark settlement with the National Federation of the Blind in 2017, requiring both to provide training to drivers and to prohibit drivers from knowingly or repeatedly denying rides to people with service animals. So I've talked about arbitration before a little bit, not a whole lot. And it became a big issue in the lemon law field because the lemon law in Michigan and in most states has an arbitration provision in it. And it actually says that if the manufacturer participates in an arbitration program and it meets certain requirements, that they can push people into arbitration instead of just having them go through the court system to get their lemon law rights. And for a long time, the automakers in Michigan ignored that. And somewhere along the line, General Motors and Chrysler have both made noises about, you guys really ought to do arbitration instead of filing lawsuits. And you might say, well, Steve, why would you care? Why would you care? Some auto manufacturers have simply created their own arbitration processes. They'll set up an organization, they'll put it together, they'll hire the arbitrators, they'll write the rules, and they'll say, this is who you got to use. And most people look at that and go, that's obviously unfair. But when it's, push comes to shove and we've had to litigate these things, one of the things that we've had more fun with is when we get the resumes of the proposed arbitrators. So in other words, they'll say, you've got to go to arbitration. And I'll say, fine, Send me the rules. Send me a list of arbitrators that I get to choose from, if in fact I get to choose. And they'll often say, well, we're going to send over a list of 3, and you get to strike one, we get to strike one, and the third person is who we're left with. And they'll send over the resumes. And all 3 of the people are retired employees of the company that we're going after. Now, they don't work there anymore, so maybe they don't have the same allegiance as they did back when they did work there. But I suspect the reason that the manufacturer has chosen their former employees to be their arbitrators is because they found a bunch who like them. So it's strange, and I hate to go off in too wild of a tangent here. I think I've talked about arbitrations in general. I've had some really, really good results from arbitration. I've had some really, really dumb results from arbitration. Arbitrators often can do anything they want, meaning that they're told you have to follow the law, but they'll say, oh, and by the way, anything they rule on is carved in stone, and you can only appeal it on the grounds of if you could prove that they took a bribe, for instance, or something crazy. But generally speaking, just because they're wrong, you can't appeal it. That's the whole point behind arbitration. And so it's good in that there's a finality. It's bad in that they can do crazy stuff. And one of the more amusing stories I had is I had an arbitration once where my client had signed an arbitration agreement as part of a purchase agreement. He didn't know he'd signed it. Like most people don't spot these things. And defendant said, we want to go to arbitration. So we went to arbitration. And at arbitration, I asked the arbitrator to award my client, I think, $7,500 and $2,500 in attorney fees. And the arbitrator awarded us more than that. No question. The arbitrator gave us more than we asked for. And I got the award, and I looked at it and said, great, we won. My opposing counsel called me immediately. I could tell it was him when the phone rang before it got answered. I bet he's opening his mail right now too. And he goes, Steve, the arbitrator screwed up. I go, how so? And he goes, he awarded you more than you asked for. I go, so? And he goes, well, that's wrong. He goes, I said to award this, you said to award this, and he awarded this. And it wasn't astronomical, but it was substantial. And I realized both those are hard to define. But I go, arbitrators can do whatever they want. And he goes, I'm going to file a motion to have this set aside. And I go, based on what? And he goes, you'd agree with me that he exceeded his authority. And I said, no. His authority as an arbitrator is he can do whatever he wants. And he did what he wanted. And I believe that there's an argument to be made that legally speaking, I could figure out a way to demonstrate that he could have gotten that number somehow. I guarantee I could figure it out. And he goes, I'm still filing my motion. I said, let me ask you a question. He goes, okay, what's that? And I said, you said we were entitled to something. You picked a number that was above 0, correct? He goes, yes. I go, I said we're entitled to this. Okay? And you seem to think that the number has to be in here. And he goes, yes. And I said, so if the arbitrator had given me 0, would you agree to set that aside? And there's a long pause in the phone. He goes, screw it. So didn't file a motion to set it aside, as he shouldn't have. But the point is that generally speaking, arbitration, it can be very simple and it can be very, very complicated. I've seen arbitration organizations where they actually have sets of rules, commercial rules, consumer rules. The rule books are this thick. And it's not as complicated as litigation, and it certainly is a little bit faster, but it can be expensive. I've seen it before where just to initiate the arbitration, you got to spend hundreds, if not thousands of dollars. And you go, wait, I thought this was supposed to be cheaper than litigation. Well, it is if you're not using an attorney, but the filing fees can be exorbitant. But the point is that once you go in there, you don't know what's going to happen, but you're going to be stuck with it. So it just looks like this case was probably egregious. It's probably presented really, really well. And it sounds like the argument in defense of this was, well, we're just an app and we just put these people together and whatever happens between them is their fault. Or, that's their business. It's not us. But it sounds like there's been a history in the past of people telling Uber that if you are providing a service like this, and there is a way to make it to where you can accommodate people as required by law, you probably should do that. And now I know there's going to be somebody in the comments. Watch Steve predict the future. Someone in the comments is going to go, Steve, if I drove for Uber, I wouldn't want a dog in my car either. Well, you know something? You shouldn't drive for Uber then, because that is a realistic possibility that someone who's got a dog, for instance, because they're blind, travels with their dog. And if you pick up someone like that, they get in, so does their dog. And if you don't like that, I guess you can't drive for Uber. Unless, of course, you want to help Uber get hit with another $1.1 million judgment. So there you go. Rachel Sandler wrote the story for Forbes. It's a fascinating article. Like I said, it wasn't a court. It was an arbitration that awarded $1.1 million. So Uber ordered to pay $1.1 million after a blind woman says she was refused service to the point where she actually lost her job. Caleb sent a thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Put off everything until tomorrow. You've made enough mistakes today.